So this is the module 2 question for the 2019 paper, alright? So define the term judicial review. This is a repeat question. Go ahead. Anyone?
Sir, it's when the High Court exercises it's when the High Court exercises its jurisdiction over inferior courts such as like tribunals and other body functions.
Hmm. That's an interesting approach. It sounds oddly like appeal, right? Appealing and overruling a case. It sounds oddly like that. So we want to make sure that you distinguish your definition enough. So it's more like judicial review than appealing. I'm not saying that your definition is wrong, but it sounds like appeal. You want to distinguish it a little bit more. Alright? So could anybody else say with distinguishing it? Give this the features that make it different. Go ahead.
Judicial review is defined as a jurisdiction of the superior courts to review laws, decisions, acts, and omissions of public authorities to ensure that they act within their powers.
Okay. So we're looking at the High Court or the Supreme Court's power or rights or function of reviewing the decisions and processes and decisions, right? Not only decision making, right? Not only the decision itself, but the process of decision making, right? Of public authorities, legislature, or any type of public body or personnel, right? To determine the constitutionality or legality of said decision making process or decision. Full stop. That is what judicial review is. Alright? That is generally what it is. And I think it repeated just a while ago. Because they asked the same question. What is judicial review? Alright? Outline 3 elements of the right to a fair hearing and state 2 decided cases regarding this right to a fair hearing. I want you guys to go ahead. I see some papers. I see 22 papers. I'm gonna download it right now. Anyone? The 3 elements to a right to fair hearing. Remember, we're gonna have impartial and independent tribunals, right? Well, and independent. So they're gonna be completely impartial, as each person has the right to a fair hearing. You're trying to make sure that it's conducted in neutral and independent decision making, right? There's gonna be adequate notice and overall knowledge, right, of the issue. Of the charges, right? So that would make sure that since the person knows the charges, they would have have notice of when the trials are going to take place. They would have adequate time to prepare sufficient evidence and information and time, right, to actually produce a proper and fair trial. Because imagine going into a trial and you don't even know the charge. How are you going to prepare yourself? Imagine getting told what the charges are 5 minutes before the hearing. That's not going to be a fair hearing. So you need adequate notice and knowledge of the charges, right? And you need the right to present and challenge evidence. The right to present evidence, right? So you must have the right to present evidence as well. So I have those things as well. So we have that the right to challenge as well. It's really the right to challenge, I guess, and present evidence, right? So that those things are three elements that would lead you to a fair hearing, right? What are two decided cases regarding fair hearing? Anyone? Use the chat if you guys want. Go ahead. I feel a Ramesh Maharaj versus the Attorney General coming out though. I can feel that case being used by somebody in this meeting. Because that case is so flexible.
Sir, and you could also use Collimore versus the Attorney General.
I'm okay, so the thing is I'm scanning through the facts with my brain to figure out how we could use that for the fair hearing thing. Cause that was an issue of constitutionality more so than fair hearing. Cause it was an issue with the separation of powers more so than the fair hearing. Let's see if we can get a better one to use, like an easier one to connect to fair hearing. There are ones that are specific about fair hearing, you know, like the Maharaj that I know that somebody is going to mention. But any other case? Any other case at all?
Sir Booker versus Widow. So when I do this case, they may repeat.
Yes, Booker and Widok. We did these cases already, right? So remember, well, this is a repeat, basically a repeat question. These are repeats. Both of these are repeats. There's only C didn't repeat. Right, so Booker and Widok on those cases, right? C. Tom, a police officer, was suspended by the Police Service Commission for negligent rather, actions while on duty. Right, that's fair. A tribunal hearing, right? Ramon, the head of the tribunal, gets angry at Tom's testimony and claims that he has heard enough from other witnesses to dismiss Tom. Right? Ramon then denies Tom any further opportunity to defend himself. Look at that. Deny him any further opportunity to hear himself. Well, to not hear himself, defend himself against any other allegations. Advised Tom on the grounds for judicial review available to him and any three remedies. I did speak about the remedies. 3 remedies that the court may apply and use 2 decided cases. Right? Lovely. And these are literally the same cases that you put up here now. I think this is such a terrible question. All of this is terrible. Because after you look at judicial review, right? The cases that you use in B can be used in C anyways, right? And we're going to be using judicial review, which we just defined. So that means that if you don't answer B and you don't know anything but B, you're quite salt. You're bread butter, right? You can't answer your question, right? So, I mean, such a terrible